This is the IFAS podcast. I'm Laura Osio. On December 13, 2010, the Palestinian High Court issued its final verdict on the lawsuits challenging the decision of the Council of Ministers of the Palestinian Authority, also known as the Cabinet, to cancel the local elections scheduled for July 17, 2010. The court ruled that once the Cabinet calls for elections, it does not have the authority to cancel them. This eagerly awaited decision puts an end to the judicial process that began on June 1, 2010, when the Cabinet informed the Central Elections Commission that it would cancel the election since Gaza was not participating in the nomination and registration process, and the West Bank's participation was minimal. On July 18th, 4 electoral lists responded to the Cabinet's announcement by filing a lawsuit, challenging its right to cancel elections. Vladimir Pran, IFA's chief of party in the West Bank Gaza, talks to us about this legal case. Vlad, what are your thoughts on this judicial process?
It was actually very interesting to observe how the court handled the appeal that challenged Cabinet's decision to cancel elections. The proceedings were carefully observed by Palestinian political factions and Palestinian Elections Commission, and I think that it is important to acknowledge that the judicial process was fairly quick and efficient. Also, we have to say that we saw no evidence of attempts to inappropriately influence the court's proceedings, either by the government or some other political stakeholders. But another thing worth pointing out is that the additional value of this process was that the court accepted jurisdiction in this case. The court refused the Cabinet's argument that cancellation of elections is political matter and matter of sovereignty, and therefore beyond the reach of the court. And I think this is an important point because it counters the doctrine under which political actions are not held accountable to the constitutional and electoral laws.
Does the ruling of the court mean that the electoral process will be automatically resumed from where it was interrupted?
No, the electoral process will not be automatically resumed, as the Palestinian Elections Commission requires direct instruction from the Cabinet. Elections Commission informed the Cabinet that it is prepared and ready to initiate electoral operations, but only if Cabinet instructs them to do so. Without Cabinet's decision, which will provide new date for the polls, there will be no elections. Also, it is important to understand that even if the Election Commission would be willing to resume the process, for legal and technical requirements, they need to effectively restart it from the beginning. They cannot simply continue at the point where the process was interrupted. The Elections Commission will need to reopen voter registration centers, what requires 3 months from the legal call to elections to the election day.
How will the court's decision be implemented, and what is the next step?
The court actually stopped short of providing instructions to the government on how to implement the decision. It appears that this is not in the High Court's authority. The legal framework in Palestine does not give power to the High Court to order the Cabinet to reschedule elections. The judicial process is actually finished. So, in effect, the Cabinet can ignore the court's ruling and maintain the status quo. Palestinian Elections Commission and Palestinian political factions are anxious to learn what will be the conclusion of the Cabinet, as it seems that the Cabinet will be discussing the ruling on 21st of December. We will know more after that.